Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to specifically discuss one visa that's sort of a interesting little niche visa, the K-3 visa, in the specific context of a Khmer Cambodian national who would be seeking that in connection with marriage to a U.S. citizen. Let's be clear, you got to be married to a U.S. citizen in order to apply for a K-3. First things first, as previously noted in my sort of preamble, we're located here in Bangkok. We do deal with a large number of Thai cases, but being fairly geographically close to Cambodia, over the years we've done a fair number of Cambodian cases or cases that arise with a Cambodian national, Khmer national involved. That being stated, it should be noted that the K-3 is an interesting animal. To provide a little background on what the K-3 visa is, the K-3 visa was created pursuant to the provisions of the Life Act created under the Clinton presidency, and it was created at a time when the backlog associated with spousal visas, CR1 and IR1, and there's another video on this channel specific to CR1 and IR1 visas in Cambodia. Basically, at the time, it was taking multiple years to get finalized Department of Homeland Security pre-approval on approval of the petition for marriage visas. Meanwhile, at the same time, it was like 6 or 7 months, 8 months to get a fiancé visa petition approved. So you ended up with this sort of counterintuitive situation where fiancés were moving through the system more quickly than spouses. And it should be noted that from a legal perspective, there is no qualitative difference as far as the law is concerned, specifically immigration law is concerned, with respect to a fiancé versus a spouse. From a legal standpoint, they're treated the same way. But from an administrative standpoint, they just had a high backlog of marriage visas or marriage petitions, and they for whatever reason, were either processing K-1s more efficiently or they just had a lower caseload. I don't know what the deal was, but at the time, it was taking multiple years to get a petition for marriage to an American citizen process through, and meanwhile it was taken, a matter of months for fiancés. So what happened is they created this K-3 category, and the K-3 category was created, basically they said, look, if you've got a petition on file for spousal visa benefits in the normal manner, the CR1 or IR1 category basically, you can take that filing and just do a duplicative version of that and go ahead and file for this K-3 category. You just go ahead and file again through the K line. Okay, that's basically what they did. They just took these marriage visa cases and they said, okay, it's been filed, you got to prove it's filed, boom, and you put it in the line that was processing for fiancés. And so what ended up happening is K-3 has kind of become the ubiquitous term for a U.S. marriage visa, but in point of fact, the traditional methodology of bringing someone in the United States is through a CR1 or an IR1 visa. The K-3 just sort of became rather commonplace in the lexicon with these matters because people got used to dealing with K-3s because that was effectively the way to get your spouse into the United States. It's interesting because K-3 still requires adjustment of status to lawful permanent residence. Those of you who are interested in learning about that, in order to get a green card, you have to undergo the adjustment of status process. And I urge you to take a look at the video that specifically discusses the adjustment of status process on this channel. But something to bring up with respect to K-3s in the present context. Although they may be useful under present processing conditions, in the past there was an administrative ruling that would, or an administrative, it was a policy of administrative closure that was undertaken by the National Visa Center, whereby they basically said, look, the K-3 was created for these situations where basically a marriage visa, immigrant visa case got lost in the backlog at USCIS, not lost, but stuck in the backlog at USCIS. So if we got the K-3 petition first, we'll process through on the K-3. But they said, look, if we get the petition for the immigrant spouse visa benefits first, we're going to process the immigrant spouse visa benefits. We're going to disregard the K-3. This is important because NVC's function is qualitatively different in an immigrant visa context than it is in a K visa context. In a K visa context, NVC just shoots the case on to the embassy in question, and the embassy sort of deals with all the nuts and bolts of the consular processing. In an immigrant visa context, the NVC process is much slower because NVC deals with the nuts and bolts of document intake, and in a way, I won't say adjudication, but sort of pre-vetting to make sure they have generally what they need to go ahead and continue the process and get an interview scheduled. So in a way, the K-3 may still, if you can go ahead and get one through, the K-3 may still process more quickly compared to an immigrant visa, but it's my understanding that NVC still maintains the policy of administrative closure where they get the immigrant case first. And now processing of immigrant matters has reduced, immigrant spouse matters of American citizens has reduced significantly. USCIS, to their credit, took significant substantial steps to make their process more efficient, and they streamlined it, and I think they got more staff and things to deal with those matters, and they put more resources on getting those cases processed. And as a result, in a way, the K-3 is I won't say it's obsolete, but its original reason for being there is not quite so pressing as it was at the time that it was created. And for that reason, I think it's very probable you're going to see fewer and fewer K-3 visas being processed in Cambodia or elsewhere.